Right, so in terms of an agenda for today, firstly, I'm going to kind of give a brief introduction into this area of law and the way it's developed so far. We'll then talk about that categorisation of assets, so matrimonial versus non-matrimonial. I'll then move on to talk about the two schools of thought in the division of non-matrimonial property and what they are. And then we'll move on to consider some fairly common niche issues. So the first one, how to make and deal with arguments on post-separation accrual of assets, the family home and whether that is ever capable of being non-matrimonial property, pension contributions, quite frequently something that comes up as a non-matrimonial asset, and whether it's ever right to ring-fence those. And lastly, the effect of intermingling matrimonial and non-matrimonial property. The mathematical school of thought, very much preferred by Mr. Justice Mostyn, advanced by him. The impressionistic school of thought. This is very much Moylan's school of thought. It's less precise and it's far more discretionary. Now, as practitioners, many of us prefer the former, the mathematical, because obviously that makes things much more easier to advise our clients on, and in turn it can make cases easier to settle because we have the clarity of a calculation. But actually a lot of decisions in this area of law favour the impressionistic approach, which I suppose begs the question, does the impressionistic approach actually lead to a lack of certainty and increase the likelihood of litigation? So again, another frequent issue of non-matrimonial property, premarital pension contributions. These often crop up and they're often problematic. I think that's probably because these are a needs-based and a future asset. And the element of non-matrimonial property can be substantial, especially if we're looking at second marriages. They're easy to identify as non-matrimonial when we have employment that ended prior to the marriage.